Good morning. Today is Tuesday, September the 12th, 2017. It's 10 a.m. It's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosby, will you please call the roll?
Dennis Bridges.
Here.
Mark Carthon.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Robert Helms.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Mr. President, all board members are here and accounted for.
That's great. Thank you, Ms. Mosby. First item on the agenda will be the review and adopt the meeting agenda. So move.
Second.
Got a motion by Mr. McKinney, second by Mr. Duffer. All in favor say aye.
Aye.
Opposed? Motion carries. Minutes are next in line. Motion to approve.
Second.
Motion by Mr. Rahm and second by Mr. McKinney. Any questions or discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Legal report. Ms. Spicer.
Good morning.
Good morning.
Morning.
We will start off. Let me first announce that when I get to numbers 13 through the end of the legal report, number 1, funeral 2017-022351. That's against the establishment, if you can make a note. And then number 2, funeral 2017-022521 against the funeral director. You see the disciplinary history. This was pursuant to inspection. The inspector found that the funeral director's license, and this funeral director is also the establishment manager, had expired January 31st, 2017, and that it wasn't renewed until March 2nd, 2017. During that time, 52 contracts were written by the funeral director. The funeral director did provide a response stating that the failure to renew was due to personal issues and family health concerns and a death in the family, and she missed the deadline. Legal is recommending a letter of warning both to the establishment and the funeral director.
Who realized that this had not been renewed? Was it the inspector or was it the individual?
Yes, it would have been the inspector.
Okay.
Part of the recommendation is based on the fact that this particular funeral director does not have a significant history with the board. In fact, there's no history for the director. And this is the first time that she's failed to renew, that the person has failed to renew.
What if we did a letter of warning to the funeral director and a small civil penalty to the establishment? I feel like if we don't do something, we're not keeping up with previous precedent on this, because there were 52 services held while it was, the license was.
If I can speak to the precedent, I would agree that we can issue a civil penalty to the establishment, but based on my review of some of the past legal reports, and keeping in mind I've only been with the department for a year, some of the past legal reports we have only issued letters of warning, but then in discussions with the executive director, there has been a history that this board has penalized and issued a civil penalty for failure to renew timely. So it is ultimately up to you all. I think there is precedent both ways to support whether we do a letter of warning or whether we issue a civil penalty. One of the issues that I'm sure you're recognizing is that the person did write 52 contracts during the time the license was expired. So if you choose to issue a civil penalty to the establishment, we just need to decide how much that should be. I do not think that it should be $100 per contract, which would be $5,200.
To the point of 52 contracts in that month, It's a busy month. I mean, I'm not in the industry, but I mean, that sounds like a busy month. I can kind of understand perhaps.
It was more than 1 month. It was
So-
from January to March.
So the end of January. It expired January 31st and at the very beginning of March. So essentially a month.
Go
Right.
ahead. And I would defer to you all on that because it does, to me, also seem significant, but I'm not in the industry to know full well significant.
And I guess my point on the 52 is I can see where you might have forgotten to renew something if you were doing 52 funerals in a month.
I have a question, excuse me. When did the state stop sending out renewal notices? Because this kind of coincides with this timing, I think.
We still send renewal notices. They come in a different form now. You know, typically years ago, they were in a 2-page front and back. They fill that out, mail that back in. The renewal notice now is a 1-page, giving them instructions to go online and renew online, or a number that they can call if they don't have access to online, to where they can call and get the old type renewal notice. I think that sometimes people do one of two things. They don't realize when they get that 1 page, even though we've worked and with all the reg boards have worked together to try to come up with something to make them understand that this is your renewal notice and it's significant, so you need to pay attention to it. I think sometimes they don't understand it's a renewal notice. And then secondly, I think some people just go ahead and put it up and wait till the end and think it's the old way where, you know, 3 or 4 days before it expires, I'll get it out, fill it out, and send it in, and they get caught like that. But what we do each month, Ms. Mosby runs a report of the license that expired. We call every funeral home, we call every cemetery, and we call every pre-need seller 2 or 3 days before the end of the month to remind them you haven't renewed your license. As far as individuals, we just don't have the resources to do that. But about 2 or 3 days before the end of the month, Ms. Mosby does the list, and then different ones in the office call those establishments in cemeteries. And the individuals, sometime between the end of the month and the first 10 to 20 days of the next month, then she sends a letter, and then that letter that goes to them is also sent to the field reps, so they know if there's somebody on there with an expired license, then they do an inspection to determine how long they practiced without a license and how many calls they did.
I would have been more concerned if it were 52 cases over 6 months. You know, hey, you know, she let it lapse for half a year, but a month, I can understand that. I make a motion we accept council's recommendation.
Second.
A motion by Mr. Cochran, second by Mr. Bridges. Any other discussion? All in favor, say aye.
Aye.
Any opposed? No. One opposed. Motion carries. Ms. Spicer?
Number 3 on the legal report, funeral number 2017-02-6241 against the establishment. You see the disciplinary history. This is a companion with number 4, funeral 2017-02-6211 against the funeral director. This is a consumer complaint, which is the companion also to a pre-need complaint that has been resolved. That was pre-need complaint number 2017-02-6191. That complaint was resolved by letter of warning. The consumer is alleging that the pre-need contract was not honored at death. In response, the respondent advised the consumer and provided an explanation of goods and services stating that the value of the funeral was $11,779.25 compared to the price paid, $8,647 in 2004. There was also an allegation for unprofessional conduct, which was admitted by the funeral director, as she refers to it in her response, as a loss of patience. However, the allegation of unprofessional conduct was refuted by other family members. So we have an admission, but we also have issues between the family members. We are recommending a letter of warning to both the establishment and the funeral director. This would be consistent with what we did on the pre-need complaint.
Motion to approve.
Second. Motion by Mr. McKinney, second by Mr. Rahm. All in favor, say aye.
Aye.
Opposed? Motion carries. Ms. Spicer?
Number 5, funeral complaint 2017-029681 against the establishment. Number 6, funeral 2017-029661 against the funeral director. You see the disciplinary history, which there is some significant history. However, this was an investigation regarding unlicensed activity, and the results of the investigation found no proof that the respondent was acting as a funeral director. There are affidavits from 3 individuals stating at no time did they witness the respondent acting as the funeral director, so we are recommending closure based on our investigation.
Motion to accept.
Second.
Motion by Mr. Rom, second by Mr. McKinney. All in favor, say aye.
Aye.
Any opposed? Motion carries. Next, please.
Numbers 7 and 8 is the same individual. One is against the funeral director. The other is the embalmer. It's funeral number 2017-028871, and number 8, funeral number 2017-028891. This complaint alleges unprofessional conduct of a funeral director and embalmer who are the same person. The alleged allegation stems from an arrest regarding domestic violence. The respondent failed to respond. However, since the time of the arrest, the respondent has entered a plea to domestic assault as an Alford plea. Just so the board knows, an Alford plea allows the respondent to maintain his innocence. He will be placed on probation for less than 1 year in order to attend anger management. So this is a misdemeanor plea. The recommendation is to authorize formal hearing, authorize settlement by consent order with a $500 civil penalty against each license for failure to respond and conduct not becoming of a funeral director and embalmer.
Activity take place at the funeral home?
No.
Guess we have a reason for this individual not responding to the complaint?
As a lawyer, I would assume he was advised not to respond, but this is just my opinion. I don't have any way to back this up. But if you have criminal charges pending against you, likely you would not respond to anything else until the criminal charges are resolved. They have now been resolved. But again, that's just me speaking. This individual, I was never contacted by his or the person's criminal defense lawyer or anything.
Motion to accept recommendation.
Second.
Motion by Mr. Rom, second by Mr. McKinney. All in favor, say aye.
Aye.
Opposed? Motion carries. Next, please.
Number 9 is funeral number 2017-030671 against the establishment. You see they do have some disciplinary history in 2015 and 2016. This was pursuant to inspection in April 2017. The following violations were found. Photographs of staff members giving appearance for violation of use of names of unlicensed persons and general price list appeared to be incorrect when compared to the casket price list. In response, the funeral home states that all references on Facebook that imply the staff members are holding themselves out as licensed funeral directors have been removed and the price list has been corrected. The recommendation from legal is to authorize a formal hearing and authorize settlement by consent order with a $500 civil penalty.
Motion to accept council's recommendation.
Motion by Mr. McKinney and second by Mr. Rom. All in favor, say aye.
Aye.
Opposed? Motion carries. Next, please.
Number 10, funeral case number 2017-033691 against the establishment. You see the disciplinary history with all of the issues having been closed. This also is companion with number 17, funeral 2017-033711. This is two different establishments. Well, I'm sorry, same establishment, two different locations. These are two similar complaints filed by a competitor alleging failure to itemize items in an advertisement. Specifically, on two occasions, the funeral home ran ads for two different locations for the cost of cremations and funerals. In response, the funeral home states that is only advertising the starting prices, which is consistent with the general price list. However, the price advertised is for direct cremations, which is not specifically stated on the advertisement, and the price for funerals is for immediate burials, which is not specified on the advertisement. That's a typo there. Therefore, the recommendation is authorize formal hearing and authorize settlement by consent order with a $500 civil penalty for each establishment.
I'd like to make a motion to accept the recommendation with the increase of the civil penalty to $750 per establishment due to their history.
Second.
We have a motion by Mr. Rahm to increase the civil penalty to $750, and a second by Mr. McKinney. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
So on that decision, just so we're clear, we'll increase the civil penalty on 10 and 11 to $750. Number 12, 2017-034271 against the establishment. This is an employee complaint alleging that certain persons were holding themselves out as managing a funeral home without first obtaining a funeral director license. And in response, the funeral home states that the roles have been clarified and the employee misunderstood the roles of each employee at the funeral home. We have no proof that there are any individuals practicing funeral directing without a license. So therefore, we're recommending a letter of warning.
This investigated by the...
No.
Okay.
Certainly have a long list of history.
Some of the same issues.
This employee that filed the complaint still employed by this firm?
I would only be making an assumption that they are, based on the response that was provided. It appears the employee is still working for the establishment.
What was their definition of holding themselves out? I mean, was it a Facebook post or?
No, I can give more clarification. There was a meeting involving several employees of the establishment. At that time, there was a piece of paper provided that lists the staff under the funeral director. Those persons are not funeral directors, but they are working under the funeral director. The employee that made the complaint said that he was given an impression that these people were holding themselves out as managing the funeral home. But there was a later clarification that they have certain duties, but they're not acting as funeral directors. So we don't have any proof that anyone is acting as a funeral director other than the people that are licensed at
It was
the
an
establishment.
inter-office document, it wasn't an
Correct.
advertisement.
No, it was not an advertisement.
Yeah.
There's no indication to us that anyone is acting as a funeral director, holding themselves out as a funeral director to the public. This was a meeting between employees, so we don't know what is going on with that particular employee that may have caused this, or maybe there's nothing. I don't want to insinuate that there is.
Motion to accept council's recommendation.
A motion by Mr. Cochran and second by Mr. Davis. All in favor say aye. Aye. Opposed? Motion carries. Now, this is going to be number 13.
Yes.
So,
At this time, we have one board member that will recuse himself from decisions. Starting with number 13, 14, and 15. Funeral number 2017-010591 against the establishment. 2017-010592 is against the embalmer. 2017-010593 against the funeral director. Please make note that the embalmer and the funeral director are the same individual. This complaint was filed by a consumer who states that he met with the establishment's funeral director after his mother passed away on July 30th, 2014. The complainant states he was never given a copy of the contract and was never told the amount of the funeral bill. The complainant's mother had prearranged her funeral but changed her mind about the arrangements and decided on a graveside service with no embalming. The complainant is of the opinion that the funeral director should refund him money. The complainant states that the establishment said they can't find her file and could only find a paper showing what the charge was to open her grave. Based on this, the department did conduct an investigation, found that the decedent prearranged her funeral in 1997, prior to the respondent owning the funeral home, as the respondent states he became the owner in October 2004. The original pre-need contract was for $2,995 in January 1997. The contract was funded by insurance, and at the time of death, the statement of goods and services indicated that a total charge of $5,140 was due. The remaining balance after insurance proceeds were received was written off, and there is no balance due or owing. Therefore, we are recommending closure.
Motion to accept council's recommendation.
Second.
motion by Mr. McKinney and second by Mr. Rom. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Number 16, funeral complaint number 2017-036761 against the establishment. Also is a companion to number 17, 2017-036791, which is a second establishment. Also related to 18 and 19, those are the funeral director and the apprentice embalmer. That's 2017-036811 and 2017-036831. This is a consumer complaint for numbers 16 and 17 against the above respondent funeral homes alleging inappropriate conduct with regard to the genital areas of the deceased by the funeral director, whose license has now been suspended under license number 4635 director and 4636 embalmer as of July 11th, 2017. The additional allegations involve the financial condition of the funeral home and inability of the funeral director to provide funeral directing services. The investigation uncovered that there has been one body that was not properly disposed of and left to decompose in the cooler. The respondent in number 18 and 19 has an expired apprentice registration, and there are allegations that that person performed cremations without having a valid registration. In response, the respondent states that the consumer allegations are full of misinformation, untruths, and gossip. The respondent states that the consumer filed a complaint in retaliation of potential criminal charges. The respondent states that there is an investigation underway by the police department but provided no proof of any investigation. As to the allegations listed for respondent in number 18 and 19, that individual was performing cremations without a license or registration, the respondent states that a licensed funeral director was present during these cremations and provided documentation signed by the licensed funeral director and embalmer. And we do have those documents related to 18 and 19. Therefore, we are recommending closure as it relates to 18 and 19, and authorize formal hearing with revocation regarding numbers 16 and 17, which we would also need to authorize settlement by consent order with a voluntary revocation for those establishment licensed in 16 and 17.
A motion by Mr. Rom, second by Mr. McKinney. All in favor say aye. Aye. Any opposed? Motion carries. Thank you, Ms. Spicer.
That completes the legal report.
Thank you. Next up on the agenda will be the director's report.
Thank you,
Robert
Mr. President. Just Assistant General Counsel Spicer and I knew who the board member was, but for the record, so that we're clear on the record, with the board member who's recused himself from complaints number 13 through 19, please identify himself.
That would be me.
Okay. That way we have it on the record. The performance audit update. I tried my very best to have something to report to you this time, other than we're still in the process of waiting to hear what the final outcome is. I am told that's a good thing, that since we don't have a report, that's a good thing. So without boring you while I read 3 or 4 paragraphs, I will just tell you that we'll continue to update the board as soon as we hear something. The audit's complete, and I understand that they're probably in the final stages of writing the report. So we'll furnish that to you as soon as we know something. Legislative update, there is no proposed legislation submitted to the administration from the board for consideration of inclusion in the governor's legislative package for the next legislative session. And as of this time, I have not been contacted, or our office hasn't been contacted, or Ms. Hooper from any association or anything that's proposing legislation for next year, but it might be a little bit early, so there may be some legislation making its way that we're unaware of at this time, but we don't know of anything at this time. Good news on the examination contract. That was approved on July the 14th. All the signatures got in place before June the 30th, and it was approved by the Comptroller of the Treasury and the Central Procurement Office on July the 14th. So that's going well. Ms. Hooper is doing by far almost all the work on it, but we're in the process of updating the exam questions to be where we're testing on current laws, completely current laws, and that's going to take a little while to do, but Ms. Hooper's done a whole lot of work on that already. Licensee report. This is a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of July 11, 2017 through September 11, 2017, and you have a list there in front of you of those establishments and individuals. Closed establishment report for this meeting. There are 3 establishments that reported closing since the last board meeting. Alexander Funeral Home at 584 Nashville Pike in Gallatin. Tribute Funeral and Cremation Services, 419 West Elk Avenue, Suite 4, Elizabethton, Tennessee, and Williams Funeral Home of Sharon at 135 Fawnville Street in Sharon. As far as the disciplinary action report, remember we're doing this a little bit different than we used to because of the changes with the centralized complaint. So this is a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to the Board authority and as reported on the June and July 2017 Regulatory Board Disciplinary Action Report. So each month I forward you that report, so you actually see this earlier than what it's reported to you in the meeting, but for consistency we've determined this is the best way to report it to you as long as you're okay with getting it in this. A complaint report for today. We have a total of 66 complaints open. 23 of those are against funeral director and or embalmers, and 43 of them are against establishments. That concludes my report. I'll be glad to answer any questions that anyone has. Or
Questions for Robert? If not, I'll entertain a motion.
So move.
Got a motion by Mr. McKinney, second by Mr. Duffer. All in favor say aye.
Aye.
Opposed? Motion carries. Next on the agenda will be the rulemaking by Ms. Sherelle Hooper.
Good morning, Board. You all were emailed a copy of the proposed rules that have been drafted, the red line and the regular version. So the purpose that we hope to accomplish today is to review these rules and have a working session. I would like to note any changes that the Board may like to see made, any concerns that the Board has, and answer any questions you all may have about the rules and maybe some of the rationale behind some of the rules. And I know Mr. Gribble was very involved in this process as well, and so I think together we would be able to answer any questions that you all have about them. So I'll start with the red line because I think it's easier to work from that version. It easily shows the things that were changed. Just for the record, with the red line, the things that are in black are things that are not changing. The things that are in blue are additional new language, and the things that are red are being stricken. And so just in case any of you had any questions about that, that's what those different designations mean. So we can kind of start with section 0660-02-.01, and
While we're waiting, I want to personally thank you for all your hard work and what you've put into the
thank you. I appreciate. That's my job, so I definitely try to make things easy and comprehensive for you all. So let's start with the first section. 0660-02-.01, and what I want to do is go through the significant changes, so we won't go through everything line by line unless you all prefer to do that. But in the section examine. In the section examination procedures, we made some changes just to clarify how the testing actually occurs and who's responsible for what, and just some further clarifications. So there's nothing significant there. The one change is that the LRR would only be valid for 1 year, and the requirements for licensure would not be deemed met if the completed application and all supporting documents for licensure were filed with the Board more than 1 year following the successful completion date of the LRR. So that establishes a clear deadline for everything to be on file with the Board. So that's the significant piece with that section as far as the changes are concerned. Any questions or thoughts on that particular section? We'll move to the next section, and that would be grading procedures 0660-02-.02. Again, just clarification of the actual grading procedures that are in place and further clarifying the passing grade. We just wanted it to be clear that it's 75.0 as opposed to a percentage that could be potentially rounded up if someone's score is not quite 75%. We also want to clarify that any individual who has questions or who disputes the results of the examination would be responsible for resolving that with the testing agency with whom we've contracted. So that's something we want to clarify in the rules, just so that that is clear and there's no ambiguity. And so, are there any questions on that particular section?
Questions that the applicant has in regards to the testing is taken up with the testing center. That's correct?
Yes, that's correct. They would be responsible, which they currently are anyway, but they'd be responsible for resolving the dispute with the testing agency. And then let's say there was regrading involved and maybe additional expenses, they'd be responsible for any additional costs incurred as well.
Question also in regards, for an individual that takes the test and does not pass, how long does he wait before he retakes it? I know I should know this.
There is a waiting period of 30 days, and I don't know, that's by policy, so maybe if it's not in this rule, maybe now would be the
Time to add it.
time to add it. But that's been a long-standing policy that that they can only take a laws and rules regulation test or a state board exam once every 30 days.
I would not be opposed to adding that too, just for clarification purposes.
I agree. I made a notation. I do think that that policy needs to be added into the rules. Since it's something that the board has been doing, it's better to have it in the rules. And so we can add that clarification that there is a 30-day waiting period by rule.
So they can take it up to several times a year then if need be.
Yes, up to, well, you have 12 months a year, so they'd have to wait 30 days, so maybe six times if they could fit that in there, depending on when they started in the year.
Good addition.
Thank you. Thanks for bringing that to light as well. So on the next section, that would be fees, 0660-03-.01 and .03. All of the fees are being reduced for student and apprentice registration and for licenses for funeral directors and embalmers. And so those are being reduced. The following section also pertains to fees, and there's a new addition to the table of contents and a new rule added that essentially adds a submission fee for cremation authorization forms and requires that they clearly designate the provisions that are required in the law. And there's also a fee for resubmission if the initial submission is not in accordance with the law for some reason, and the document must be revised.
Just for clarification, the only fees that are being lowered at this time would be director, student, or apprentice.
The funeral director, student or apprentice, embalmer, student or apprentice, as well as funeral directors and embalmers.
Tom has a question. After he has a question, I'd like to speak just a minute to the fees.
But just clarification for myself, the submission fee for each cremation authorization form, what are we referring to there?
Well, these forms are required to be submitted for board approval, and so when establishments submit those forms, they would also have to submit a fee because those forms have
So
to
they're
be...
seeking a license, a crematory license fee, or?
No, they are giving us a copy of their form that they plan to offer to consumers for review to make sure that we approve and to make sure that it complies with the law. And so that's the purpose of the cremation authorization form.
Typically, that'd be a one-time fee.
Typically, yes, and then it would only change if, the cremation authorization form would only need to change if the law changed, or if the organization, the establishment decided to change something. And so, let's say they changed their name, or they made some other change and they needed to resubmit, that would be the case. But some of the forms stay in place for several years, for, once they're approved, as long as the law doesn't change and nothing with the establishment changes.
Do we have a standard form now?
One on the website that any crematory can use. They just need to fill in the blanks and put their specific name and phone numbers and send to us, and use. It's forms that they want to
Non-standard.
non-standard,
Okay.
and sometimes those aren't submitted in the best way to us, and it requires legal's time, and sometimes quite a bit of time.
So if an establishment took the form off the website, just put their name on it, that's not $100, right?
Be up to the board. That's what I'm assuming that the interpretation is, but we might need to be specific about that would that
Because if
be-
they're using our form,
would that be
I don't really see charging them $100.
If our form was being used, there would be no charge. It's when they want to use their own form, which for
That makes
any
sense.
number of reasons they would want to use their own form.
Sure.
Probably legal reasons primarily, because you can add additional language, etc. But if it was our form, there would be no need to charge them to use our form. If they just assuming they took our form and just put their header at the top, there would be no need to issue that fee.
If the form is submitted by the establishment and then it is rejected because it doesn't meet the criteria, whether
Yes, there's a resubmission fee.
every time that it's resubmitted,
Yes.
Probably what they'll do, Mr. Duffer, is they'll get it in a better form to submit it in to begin with than they normally do. So hopefully they would engage their own private attorney, private counsel to submit it to begin with, and it would be in a good format, and hopefully there would just be one submission. But the way it is now, and this would only be from crematories, because remember, the board has a rule that the funeral homes are required to use the form of the crematory in which they're going to do the cremation. So this won't be each funeral establishment submitting a form. This will be crematories. And obviously, those are already approved are the ones, I assume, that are submitted before these rules are adopted. There will be no charge to. This would be after the rules are adopted, which will typically be 16 to 18 months from now. And what I wanted to speak about fees, I think probably most of you are aware, and I know Mr. McKinney was on the board when it was done earlier, and the fees for renewal of funeral director and embalmer's license was lowered about 3 years ago, 4 years ago, from $275 to $235. We've talked quite a bit about lowering fees again, and it was suggested to us that we do it for the people who are entering the profession, that those people probably have a harder time meeting financial obligations maybe than someone who already has a license. And that was the reasoning for suggesting that the funeral director and apprentice funeral director, apprentice, embalmer, and student be reduced from the current fee of $70 to $50, because if they're registering for all three, then that saves them $60, $20 on each one of them. And then the ones who complete their educational requirements and all the requirements to become licensed, currently they're paying $275 to be licensed. And if these rules were adopted, then they would pay $235, which would be a savings to them of $40 each license, so that's $80. So that's basically saving them about the price of what their laws and rules test is if they go through and get both licenses, if these rules were adopted.
Any other questions before we move on to apprentices? Okay. So for section 0660-04-.01, we made some amendments to that section, and two significant ones. Number one, well, it's actually number two in this section, just so that you can follow along. A person shall not re-register for an apprenticeship if the person previously completed an apprenticeship or less than 12 months have passed since the substantial completion, which would be over 51% of an apprenticeship. Upon a showing of good cause, the waiting period of 12 months may be waived by the board. And so that rule is designed to prohibit essentially perpetual apprenticeships. And that's what that is designed to target. Number three essentially limits the time that the board has to hold open an incomplete application, which, as you will see in the next two sections pertaining to establishments, directors, and embalmers, that's something we're doing throughout these rules, limiting the amount of time that the board has to hold these applications open, because this has been an ongoing issue with applications being filed and numerous items not being completed and taking several months and a lot of board resources to get these applications completed. So this is putting it in the rules so that hopefully once applications are filed, individuals, establishments, et cetera, are prepared to make sure that they're able to meet all the requirements more expediently. Questions about those requirements? Okay. The fixed place of business, that's our next section. That's 0660-06-.02. And we made some changes regarding signage and changes pertaining to how we would better determine whether or not it is devoted, an establishment is devoted to the care and preparation of dead human bodies. And so C, if you look under section 2C, we talk about the type of professional signage that's displayed. That would just be one of the factors. Whether it's separated, if it's inside of a business complex from other entities within the complex, and whether there's clear professional signage. And then we also had another piece of a piece of legislation that was passed this past legislative session. So one of the things to look at is the volume of preparation services or commemorative services for non-human remains, and the type and volume of advertising materials related to human as opposed to non-human remains. And there is a rule, edition number 3. There's a rule edition number 3 that basically limits the display of signage that would convey the future site of an establishment to 60 days prior to the opening to limit confusion, etc. So any questions about that particular section?
I've been allowed previously, is that correct? As far as the signage is concerned?
Again, by policy of the board, it had been a policy that a proposed establishment could put a sign up that says future home of proposed ABC Funeral Home and Cremation Center, or ABC Funeral Home, or whatever. And what we've been told is anything that's been a policy needs to be put in the rules. It wasn't specific to the 60 days, but after Ms. Hooper and I talked, we wanted to propose that for your consideration, because we don't want someone to decide, okay, I'm going to put a sign out there and I'm not going to do anything as far as preparing that for an establishment for another 2 or 3 years. So this kindly says within 60 days from the time you get, you've got 60 days before you get licensed, you can put the sign out there. It says, and there would be nothing to prohibit a newspaper from doing an article about it. It's just that the the establishment until once they become licensed, this would be the only thing that they could do to let, but it would be something to let people know they were coming.
Personal experience building a funeral home that took over a year to build. And at the time we built our funeral home, we couldn't say future home of Bridges Funeral Home. We had to say future home of
That was the one thing that kind of stuck out to me, is if you're going to allow it, you know, it's impossible to build a building in, 60 days. Did y'all have, what was the thinking behind the 60 days, rather than, say, 6 months or so?
We were thinking about it from the perspective of an individual, well, the establishment having a pending application at the time that the sign goes up, because we're limiting the applications to 90 days. Essentially, from the time it's filed, it needs to be completed within 90 days. And so the rationale was, by the time a sign like that goes up, there should already be an application pending, and the establishment should be well on its way to being actually open. Now, you all may not agree with that. If you're building a funeral establishment, maybe it is a good idea to have a sign up for much longer to say that your establishment is going to be at a future location. So it's definitely up to you all to determine what you think is best in this regard.
Well, I definitely don't think that you ought to be able to put up a sign on an empty lot and then the sign just sit there for months and months and months without any activity. But if there's actually building or construction in progress, then, I don't know. I don't know what's fair to, to the establishment owner.
I agree with you, Clark, and Dennis. I see the need to get rid of perpetual signage where there's nothing happening, but I think 60 days really limits.
60 days out, you're almost there.
Yeah, and I think anyone that has the commitment of construction and capital money, they're going to make sure they get their licensure in place, I would think.
So we sort of did the opposite of that. We built a building and we applied 60 days before we were mostly complete for licensure. So, but it was up over a year. The sign was up over a year.
How would the board feel if Ms. Hooper did something like if it was a certain percentage complete, whether it was a new building or a remodeling of an existing building, if they have attested that it was 51% complete or lower, whatever, or does that make it more complicated? And is it better just to say that they can have a sign up for X number of days, whether that be 120 or 180, or what?
Right, to the application being open for more than 90 days. Is that right?
That was the thought process, but, from the perspective of the business itself, maybe having the sign up for longer would help the business itself get the community interested in the fact that the business is coming soon. And so, I think to simplify it, it would be better to have just a higher number of days. If you all think that maybe 6 months, maybe that's more appropriate prior to the opening, to give them several months to kind of let the public know that their establishment is going to be opening soon. Maybe that's more appropriate.
You think about it, when you break ground, it can take even longer than 6 months. So do you look at hear me?
As long as I don't think you'd want to run into a situation where that they put the sign up and they break ground and they lay the foundation blocks and then stop. And then there's nothing going on for another year. There you
That's
go.
right.
Or even break ground and nothing happened for several
Right,
months.
right, because that could happen too,
Well,
People
if,
could-
if from the point, then you break ground with continuous progress being made.
I personally would think 120 days would be sufficient. That's 4 months. Everybody hear that?
How many days did you suggest?
120.
And I think that would be a better approach to just pick a certain number of days, because if we get into construction, all sorts of things can happen. There could be shortages in labor, shortages in construction materials, other complications. And so then it would seem unfair to require someone to take their sign down for matters that aren't within their control. And so I think if the board just had a blanket rule of a number of days, that would be simple to enforce, and it would be fair to everybody.
But say in a case, if say you put up a sign, future home of Bridges Funeral Home, and then, maybe at the very bottom of the sign in small letters, pending state approval, would that not be okay now, or would that not be okay now? As things stand at this point?
You answer that first. I'm sorry. I don't want to interrupt.
I think the issue is perpetual signage. If signs are going to be put up saying that there's a business coming soon, it needs to be coming soon. And
Right.
so having that disclaimer, a sign could potentially be there for a couple of years, and there would be nothing
Right.
that, the board could do to require it to be taken down absent some type of rule that puts some limits on that or some boundaries on it.
Out of just curiosity, and I ask this question sincerely, as long as it says future site, as long as it doesn't say, home of Smith Funeral Home, as long as it says future site, and I honestly am asking this, why do we care how long the sign? I mean, it seems like that would be more of a local issue. I mean, hey, your city has regulations on how long your signage is there before an establishment is actually. I just, as a board, why do we care?
The reason that historically that we've cared is because it's an establishment that's not licensed. So if you're going to, it all has to do with unlicensed activity. And if they're going to operate somewhere else, if you let someone use the name ABC Funeral Home and then they're not yet there, does that mean they can go somewhere else and operate under ABC Funeral Home? It sounds very, like you said, it sounds very simple, why do we care? But then when you look at unlicensed activity and the different complaints that we see from time to time, then there's probably, a reason to care. This all came about because, again, this is one of those things that's been done by, it's policy, and it probably needs to be put in a rule, whether you want it, or if you don't care, then we can just, when people call and ask, we can just say there's no rule that's applicable to it.
I mean, I could understand the concern more if it said home of whatever, or if it just said Johnson Funeral Home, and that establishment isn't licensed yet. I understand that concern, but if it says future home, whatever.
But it could be future home and then the future never comes.
But I don't see how that concerns us as a board. What do we care?
I think tying it back to the construction is, if legitimate construction is underway, then
That's where I was going
I
with
think it's
my idea.
reasonable for it to be there till it's finished. But
Why don't we take a look at number 3, instead of, it says at the end, 60 days prior to opening of the establishment, why don't you say 60 days prior to construction? Now, I think if someone is under construction, they should have a sign, be allowed to say, hey, we're building to meet your needs.
Active construction.
Active construction, right.
You're saying proposed Bridges Funeral Home, you're not saying it's a lie.
Right.
That's my point.
It'll give you 60 days to start construction, and then that way, you're entitled, as long as you're active construction, you're entitled to keep a sign. I think they keep it simple. Again, that's just an idea.
Maybe I missed this, Ms. Hooper, in the beginning. I think it'd probably be helpful for the board members to know, if I understand from the conversations that you've had with me, they will still have another opportunity to, or maybe two more opportunities to adjust what they decide today in these rules. I mean, what you're looking for today is good ideals to go back and revise them, but then they will have an adoption time and a rulemaking hearing that they would have the opportunity to make any fine tuning to them.
Yes, the objective today is to essentially fine-tune these rules so that they can be adopted at the next meeting and that a rulemaking hearing can be scheduled. So that's the goal today, is to actually fine-tune them. Changes could be made down the line, but they may further delay the process. Because once they're adopted, there really shouldn't be substantive changes. At that point, there can be, but the goal is to adopt substantively what you plan to move forward with at the rulemaking hearing.
I'd like to see us come up with, on that issue, somewhere a happy medium. You know, I don't want to leave it just out there hanging or leave it too broad. But then again, we don't want to be overburdensome to someone that's trying to go in business or build a new place. We want to be reasonable, but we don't want to leave it hanging out there either, you know. And we may not think so, but that will happen. There'll be people put up a sign and never, ever build a place, you know. They'll be popping up everywhere. And then they'll come in here maybe and want to operate out of a construction trailer or something, you know.
And, you know, in all fairness, that type of thing is confusing to the public, and it doesn't reflect good on the profession. So I do think the board has an interest in putting some parameters on this. Now what, you know, that's for you all to decide. It could be 60 days prior to construction. That would mean, you know, as long as they intend to start construction within 60 days, they could put up a sign, and then the entire time that construction was taking place, the public would know what the purpose of the building is. And everyone knows that's a curiosity. Anytime a new building is going up, you know, people start asking questions. Hey, what's that going to be? So if you allowed it before construction, that would, you know, satisfy, you know, those curiosities.
Of course, Mr. Hinkle's not here anymore, but he was a building inspector, and of course he could probably answer this. But does anyone know, like, just a city, if you go to the city of XYZ and they issue a building permit, is there a time frame on that permit to when construction begins, or when, if you don't build, then you got to go back and get another permit? Are there limits on the local level?
I'm not aware.
I'm not sure. I would say there are.
Or you may have an idea.
Well, I'm from McMinn County. We don't do building permits. I mean, the cities do, but county construction, you don't require a building permit. We're from the last bastion of freedom.
Maybe you should.
I see in their local paper where people go back and go back to the planning commission and get an extension because they failed to do. It's my thinking that where I live, it's probably 1 year, that it's got to be completed in a year, and if it's not, or maybe that's just a substantial amount, because like Mr. Bridges said, it may take longer than a year to build it.
As long as ours was ongoing, it just extended. Wrong with saying 60 days if nothing happens, if no activity happens. But if it's an ongoing site, and you know, it just takes, it's not like a Zaxby's, they can come in and build them in 60 days and get out.
My question is, the word construction, how is that going to relate to an individual that's already has a building constructed and plans to open a facility?
That's a good question, because everyone is not going to be constructing a building. Some people are going to be renovating buildings, or just, you know, making smaller changes that, you know, will take time, but not really be identified as construction. And so there would have to be some language to address those situations as well.
You could specify new construction versus existing structures.
Or go back to just set a certain time frame, a certain number of days or months.
And I mean, that could be a year. I mean, you all could say, shall not be displayed for more than 1 year prior to the opening. And, you know, that could cover all concerns. And, you know, if someone wanted to keep their sign up for a full year, they could. Or if they, you know, wanted to put it up lesser time, they could.
Just throwing this out there, what about if we allow the individuals to get approval for an additional year if they show cause, you know, or a time frame?
That's certainly an option too. That would give them some discretion. Well, it would give them an option where the rule would not require them to take the sign down if it wasn't done in a year, but that they could come to the board and kind of explain why things are taking so long. If they've advertised to the public that there's a funeral establishment coming to their community.
Well, from the public's perspective, I don't think, I mean, after it's been up for a while, they would get somewhat,
Kind of old news.
yeah. And so,
So do you all think a year is more reasonable prior to the opening
I think make it a year.
with the opportunity to come to the board for an extension?
You know me, I was going to be somewhere in the middle, so I was going to say about 6 months, but
I mean, it's definitely, you know, whatever you all
year's a long
think
time.
is best.
I'm just trying to find a happy medium, you know.
Administratively, I'd ask you not to, just to set a time and not to do a renewal, because then you get into the perpetual signage, and like you say, after a certain, I mean, even if they're doing it, and like Mr. Bridges said, it may take a year and a half to do it, or if it's very complex, maybe longer than that. But like Mr. Alm said, at some point, you know, you lose the public's interest if you have it up for a long, long period of time. So I don't know what that is, but it would be easier administratively if they didn't come back and reapply, if you just set a time and they knew when they got within that time, then that they could put the sign up, if whatever time you think that is.
I do know from experience that when even if you have the property, once you purchase the it can take 7, 8, 9 months, depending on the weather, when you start breaking ground, to really get that point to where you can have that examination and open up the doors. I know a year sounds a long time, but when you're in construction and getting a funeral home built, and I've built 2 or 3 of them, different, some are quicker than others.
I still think if you have active construction, you should be entitled to have that signage.
I think if the sign goes up, something should happen in 60 to 90 days. Some activity should happen, but if it's under reasonable construction,
Clean that up and come back.
Well, I'm gonna have to get some instructions.
That's right. You've got 7 opinions.
So you all, is the consensus that as long as there's construction taking place, so let's say some establishment.
Active construction, that would take care of new construction and existing,
Okay.
like a remodel or something like that.
So does it matter, let's say it's a 2-year process, does that matter?
Let me predict what's going to happen if we do active construction. So I mean, we dealt with a case today where there was a competitor's complaint. Every time there's a new funeral home being built, the competitor across the street, if they see the work has stopped for 4 days, they're going to call your inspectors, and you're going to have to go out and see, well, when was the last time a block was laid? Is the construction still active? that seems to be a trend. I mean, just in my short time on this board, that the competitors tend to complain about their neighboring businesses, and that's my prediction. If you do active construction, Joe Schmo down the street's going to say, well, they haven't been there in a week. You know, send out the inspectors.
I think that's realistic. I think that's a realistic possibility. And so I think maybe we should stay away from active construction. And I do think when a business decides to put signage up is a business decision. And so let's say this rule said 18 months. Someone's going to wait right up until 6 months because they think that's going to create more excitement. Someone's going to want a sign out there right at 18 months because they want people to know, you know, as soon as they break ground that they're coming soon. So I don't think we should be too concerned with giving them too long of a time. I think from what I'm hearing from you all, we need to be concerned with giving them too short of a time. So, and that's based on, you know, just listening to you all today.
I think too short of a time is just, it's just hindering, maybe hindering progress or something. But has there been a case where that someone has went to the expense to build a facility or has done an extensive remodel of a facility, and then them come for an establishment license and then be flat turned down? That you can recall.
I'm not recalling anything at the present time. Do you, Ms. Mosby?
I don't recall any either as well.
We've had some applications turned down back a few years ago where they didn't meet all the requirements, but then they would eventually meet those requirements. I'm not sure if the applications were denied or tabled. I'd have to go back and check that to see which. It's not 100% that every time someone comes before the board that they get approved the first time. But I can't recall anyone who's spent a substantial amount of money on an establishment, on a building, and it be turned, an establishment application be denied.
Ones I remember are the ones that they were tabled until certain criteria were met, and then you were able to approve them after they submitted those documents.
Another 30, 60 days, maybe,
No longer than 30 days.
something like that.
I mean, one option, and all this came about because of board policy, which needs to, you know, become a board rule in some shape, form, or fashion. One option is just to remove the second sentence and just say that they may display such signage, and to not put any parameters on the time whatsoever, but just have it in the rule that they can put that signage up so that, you know, if there is a sign that doesn't indicate that it's the future site, but maybe gives the impression that it's a licensed establishment before it's open and operating, you know, the board would be able to better support disciplinary action if someone were to do that.
I'm personally fine with that. I mean, again, if it stayed there for a long time, at some point people stop paying attention to it, and it has no effect anyway. So I have no problem getting rid of the time limit. I'll let the market decide it.
That gets us back to the perpetual signage, doesn't it?
Yeah, spike in the location, never do anything about it.
Right.
I'd rather go back to the happy medium. Go back to the happy medium and put a year or something on it.
Do y'all think 18 months? Because I know we were saying a year is a healthy amount of time, but then we also wanted to kind of think about potential delays, et cetera. Do y'all think 18 months would be a reasonable time limit for such signage?
I had a question I wanted to ask Mr. Bridges and Mr. Duffer, because they both built new businesses. In your situations, did you want to put a sign out there when you had the groundbreaking, or before you had the groundbreaking, saying that it was going to be a future site of such and what?
As soon as you purchase the property.
As soon as you purchase the property, you want to let people know that.
Yes.
That's what we did. But again, we put future home of proposed, so we weren't making people think that we were already live on the board.
But, and I'm just trying to think of something that would put a policy in rule and something that would be very fair, but still have some regulation to it. What if the rule said, and Ms. Hooper would have to put this in legal terms, but basically, once you purchase a property, have it zoned, and is there anything else that has to be done for you to go build that building? I mean, would it be a permit of some type from the local zoning authority that you would obtain to build? Would that, if they had those things in place, then they could put the sign out there anytime they wanted to? Would that be fair, or is that?
I think they would. I think if they choose to put it, and let's say the 18-month thing, if they choose to put it up when they buy the property, and the clock's ticking, the zoning, and all the approvals, state approvals and all that, not board approval, then that gives them less time during construction, and maybe they start within a certain period of time after the sign goes up, and it ends at a certain period of time.
I mean, personally, just from listening to you all, I'm kind of concerned about putting a time limit just because of what I'm hearing. Even though perpetual signage is a concern, I think maybe the rule just needs to say, and of course this is, you all's decision, but maybe the rule just needs to clarify, instead of a time limit, clarify that the signage shall not convey or suggest that the establishment is licensed prior to obtaining licensure. Maybe that needs to be the direction of the signage, because it seems like there are so many variables that coming up with a time limit would be potentially unfair, depending on any number of circumstances that could be beyond the owner's control. And those are just my thoughts, but ultimately you all would make the decision.
And I mean, look at industries that are completely unlicensed. I mean, as far as from a state board, restaurants, whatever. There's not. I mean, people who are hotels, people who are building buildings. There's not really a perpetual signage issue, and they're unlicensed. They're not. I mean, they're unregulated, I should say, as far as from an actual sitting state board. There's no one saying, "Hey, you can only keep this sign here for a certain amount of time." And you're not driving around your town saying, gosh, that future home sign has been there for 3.5 years. It's just not really an issue. It's not where I live, it's not an issue. Perpetual signage, I don't think is going to be a real, I don't think if we got rid of this rule that tomorrow 150 funeral homes are going to say, future home, we're putting our sign up. It's just not going to happen. I have no problem with that recommendation of getting rid of the time limit.
Charles, did you go sleep?
I think the licensed current establishments need some protection from that, to keep someone from putting in a new business and saying, and leaving that sign up forever. I think that
And
hurts.
it will happen.
That's very possible.
Yeah, it will.
To what benefit, though, would they leave it there for future home for the
Pure aggravation.
Talk.
Yeah.
Talk, gossip, rumors,
Yeah.
small town.
Yeah.
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 Well, how about 18 months?
I think that's ample.
I think it's ample too, and if they choose to put it up when they buy it, and it's a year before they start, then they roll the dice. It doesn't get to stay up the whole time.
And plus, they'll know ahead of time that it's 18 months. So, I mean, they can decide, they can kind of weigh the benefits of when to put the sign up and when not to.
Or get along with that? I think we're good.
Not really, but go ahead.
Mr. Palmer's yielding.
Just when almost everyone's in agreement.
6 out of 7 is not bad.
Well, Mr. Duffer's never said whether he's in agreement yet or not.
I'm in agreement with, I'm certainly not in agreement with the 60 days or 4 or 5 months, because I personally have went through that, and as much as I wanted that building to be ready and open to the public, it just doesn't happen. But you want that sign out there to let people know. And like you said earlier, there's different circumstances that happen that we can talk about all day long today that we won't cover. So what is the best answer? You know, if it's 18 months or a year?
Can't cover it all.
I don't
And
know.
as Mr. Davis pointed out, we did an extensive remodel, and it was over a year and a half. And it wasn't new construction, it was a remodel.
Yeah. It takes a while.
I mean, do you think 18 months is sufficient, or should it be 2 years? I
No,
mean,
no, no,
okay.
no.
Everyone say no to 2 years.
I'm still on a year, but I'm not going to holler at a year.
Sounds like 18 months is the consensus. Is that fair, or?
I think that's as good as it can be.
I think 2 years is a long time. 18 months is like a lot way out there. I mean, I was comfortable with a year, but whatever.
Got one, and I got to vote for a year.
Well, I think that probably is a good, happy medium. And so,
Mr. Cochran said year on the beginning, till we gave him time to change his mind. He said year on the beginning.
Well, a year was better than 60 days. That's why I was on the far end of the spectrum.
and we were just thinking about it from a getting licensed standpoint, but
Yeah.
from, you all who have actually, built funeral homes, et cetera, there's another element to this. And so I think that's what you all are taking into consideration. Right.
Now that we have gotten through number 3, can you back up just a hair?
Yes.
And just in a synopsis version, can you give me some clarification of the latter part of C through F?
So C through F is basically saying how we would determine whether or not an establishment is devoted to the care and preparation of dead human bodies. So those are essentially factors that we would look at to see if an establishment is truly dedicated to the care of human bodies.
How are we going to do that?
So we would look at those number of factors and weigh it, and if something was off here, then, let's say we received a complaint or we just became aware of some information. At that point, and there were already a couple here, as you can see, those are in black, but we added a few more based on E and F were added based on the new legislation that's passed. But upon looking at these factors, if something was skewed, that might raise some concern, and the board might want to take action if the establishment does not appear to be dedicated to the preparation of dead human bodies. And so you would look at, the signage. If I can't begin to imagine the possibilities, and some of them may never arise, but you would look at the type of signage, how it's separated from other entities. For example, if
And I may be getting too far ahead because of what's in here, but if a firm wants to handle pet services, can that be placed on their sign? Is that a part of this, or?
I think that would just be one of the factors where you would determine, is this entity dedicated to the care of human bodies? So I think that would be one of the factors, but it wouldn't be dispositive, meaning if your sign said, per your example, that you also offer pet care, that wouldn't be dispositive, and it wouldn't mean that your organization is not devoted to the care and preparation of dead human bodies. But that would be one of the factors, along with all these others, that would be looked at. And ultimately, these decisions would be made by you all, the board, if a strange case arose.
Well, it's just giving leadway for your inspectors to use their judgment on C through F, is that correct? Basically.
Yes, and to give the board some guidance should matters come before the board. I mean, we really don't see a situation in this industry where we have multiple types of establishments in one building or, you know, because of the nature of the industry. But it's just unclear what may arise in the industry. You know, things are continually becoming more innovative, which is good. But with that, you know, the board needs to be able to evaluate things as they come along.
Like E would say if a pet funeral service business came in and they were doing, you know, 100 pet funerals a year, and then they wanted to do humans, and maybe they did 2 human funerals a year. Is that what we're getting at on where it says the percentage?
Yes, that would be a factor that you all would look at, and or that the inspector and you all would look at. You know, the investigators would look at kind of what's that ratio look like, because ultimately, you know, we're required for these establishments to be devoted to the care and preparation of dead human bodies, and so that would be a factor. And of course, if you all saw it and it was skewed to that extent, realistically, you all may see a problem with that. And it doesn't just deal with the pet care issue, because, you know, several of these were already in place. I mean, we just don't know what individuals may decide to, or is combining different types of businesses, and whether or not that's going to affect fundamentally what the establishment is licensed to do.
As badly as I don't want to debate it, let me ask you this question. Should, at this point, we make some sort of determination on the percentage? I mean, would that avoid having to do a formal hearing on a case later where the rule isn't extremely clear as far as the volume of human, you know what I mean, as far as the volume of human funerals as opposed to pet funerals? You know what I'm saying? Should we actually make it clear now, hey, there has to be this type of ratio, or?
I would not recommend that. I think you want to keep the discretion to look at the whole picture.
Yeah.
And so I wouldn't recommend coming up with a percentage right now, but to keep the discretion to look at the whole picture
Okay.
and be able to make a decision.
I'd let that dog sleep right now.
No pun intended.
No pun.
So are we clear so far on that part?
So,
And are we in agreement on 18 months on number 3?
Yes.
and that's prior to construction. Okay.
Prior to opening.
Prior to opening.
Right.
Sorry.
Of the establishment.
Opening of the establishment. So moving to the next section, the requirements for a crematory, that's 0660-09-.01. Significant changes, the requirement of an acknowledgement of receipt and a photo ID for individuals picking up cremated remains, and going back to the non-human, human body issue, limiting the use of cremation chambers, refrigerators, urns, and other containers to either one or the other.
So when I have a family come back to pick up the cremated remains of their mother, father, whoever that I've worked with, I'm going to have to ask them for their driver's license so I can make a photocopy of it, even though I've worked with them and I know them. And
Per this rule, yes, you would need a copy of that on file, and that would be helpful in the sense that we get a number of complaints about who has authorization to pick up, the remains, and so that would be helpful to know with certainty who actually took possession of remains.
And this says crematory. All right, what about, see, I use a third party. So if I go to the crematory and pick up the cremains, I'm going to have to give them my ID. Okay, then once I get the cremains back to my funeral home, and then a family member comes in, see, it doesn't say anything about the funeral home.
I think
Shouldn't
that's- yeah.
Because to me, it would be more important for me to get it, because when I turn it loose, it's gone. You know, and I could see a scenario where maybe, you know, mom has dad cremated, and maybe there are 3 children, and one of the children comes in and says, I'm here to pick up the cremains, and you hand them to them, and off they go, and then next thing you know, the spouse comes in, wants the cremains, and, you know, they were going to bury them or put them on the mantle or what have you, you know, and then maybe this child that picked them up, maybe he threw them off scattered them somewhere, and you can't get them back, you know.
I think to your first point, I think that's an excellent point that needs clarification. I think we do need to clarify that the objective is not to get the funeral director's photo ID from the crematory. The objective is when the remains are released from either a crematory or an establishment, that there be a record of who got the remains.
In the recipient.
The recipient
Yeah.
of the
End recipient.
remains, the end recipient.
Right.
So I think that definitely needs some clarification that it applies to the crematory and or the funeral director. Well, it wouldn't. It'd be one or the other. The crematory or the funeral director would have to get these records to ensure that the end recipient is known.
It should be the person that's, you know, legally entitled to.
Should be established at the time of arrangements.
Yes, and
As
there are
to
a
who
number.
the recipient of the cremains is going to be.
And you're not necessarily saying that, just to clarify, so not necessarily that the person would have to present their ID on, to his point, you know, if you know this person, but if you've got their ID already on file from when you originally did the paperwork, right? So when you
I usually get an ID of, I mean, if I
Right.
know them, I don't say, hey, Joe, I need your driver's license.
right,
I won't have to.
okay,
Yeah, if you already had it on file, we wouldn't say you have to get it again
and they pick it up.
when they pick it up.
Hopefully for that family, you're not doing that much business with them that you'd have it on file.
Right.
To clarify end recipient on that.
This might be it's just an extra thing that we're going to have to ask of families, but as far as liability, it's it's actually would be good for the funeral home to do that.
And, you know, it could become, I'm sorry.
Do y'all have any regulations in place now that deal? Yeah.
We do.
Okay.
We take photo ID.
I thought you did. Yeah.
And it could be a may obtain photo ID. It doesn't have to be a shall. I mean, you know, from a practical perspective, if a serious issue arose, it'd be great to have that on file. But, you know, that could become a may as opposed to a shall obtain photo identification.
So if it was somebody that we personally knew, then yeah. Mhm. Didn't know them, then we could ask for it.
And maybe the photo identification could be taken out altogether and just require the receipt and the acknowledgement, but in a strange case, an issue could arise. You know, obviously if it's someone in your local community that you're familiar with, you don't anticipate this type of thing, but
If you left it shall, I imagine that's something else. Could you be dinged on that on an inspection if they were going through your records and, you know, they didn't see that copy, then that's something else they can.
I think if you leave it shall, it would, and this may be something to Mr. Ron's point, it may be something you want to put may, then that way if you decide to do it, the family doesn't have a reason to fuss about you doing it. But it'd be your discretion as the funeral director as to whether or not you, and that would prevent you from the embarrassment of saying, hey, I've got to have a copy of your driver's license. I know who you are, but I've still got to have a copy of your driver's license. If you didn't, but then Mr. Puffer, I guess in each case, you do it, right?
We do. Even though if you know them, I mean, and our families have said they appreciate that because anyone could walk in and retrieve those cremains and sign the document, and it may be, once they're gone, they're gone. So we haven't had an issue with it.
Haven't either, but in case of the informant, the legal next of kin, if another family member requests some of the cremains, then they need to approve it. The legal next of kin needs to approve it before we.
Have it in writing.
Yeah, we do a release form.
Mm-hmm.
Yeah.
I think it's good business practice to get the signature of the end recipient, and I think it'd be nice to have the may get a copy of the driver's license, the photo ID.
I'm for the may myself.
Yeah.
We can make that change so that it's may obtain a copy of the ID, and then that way it's not punitive against the establishment or the director, and it's in their discretion to do so. It's clearly within their discretion to do so should any questions be raised about it. And then any other questions about this section? I know 11 and 12 deal with the human versus a non-human remains. Questions or concerns about that?
I had brought this up, maybe, might have been even the last time that I was on here, about if you have a business that has, say, a human retort and a animal retort sitting side by side, you know, common sense would tell you, you know, one's for humans and one's for animals, but
They currently have to be separated by a wall.
yeah, not now.
They don't?
Not now. Not anymore. Isn't that right? When they passed the legislation this year, I think it did away with that. My thought was that the refrigeration areas, storage areas, and the retorts, if you've got both, they ought to be labeled. Just so the extra reminder there not to put an animal in the human refrigeration or retort. That was just a thought that I had. So it's clear to the operator and whoever which is for which.
I think that's a good point. It also helped the field inspectors when they make their physical inspection.
Would that be applicable to any chambers and refrigerators only?
Yes, ma'am.
Okay. Retorts, chambers, and refrigerators? Okay.
The way you're using it, I guess a chamber and a retort's the same thing.
Okay.
In the way that the rules written.
They shall be labeled as one.
Appropriate signage.
which is being used for what? Because you don't want the field reps to go in a cooler that's got humans in it and then find animals laying in there too.
We can definitely make that change. So moving on to the continuing education requirements, we have that section 0660-10-.03. That is in response to legislation that was passed as well. And I guess we can also look at the next section at the same time because it all deals with continuing education. Essentially, the section .03 pretty much mirrors the statute. Now, we do put in there that a licensee can get 1 hour of CE credit for attending a regularly scheduled board meeting, and that's in-person attendance, and that they can't repeat the same continuing education courses within consecutive renewal periods. That's also board policy, so we're just putting that in a rule. And also clarifying that this is also applicable to those reapplying as if for initial licensure, they still have to meet these CE requirements. If they're doing a reapplication for some reason. The next section, .04, just clarifying that the program needs to be 1 hour. It's not 50 minutes. A credit hour equals 50 minutes, but the program itself needs to be a 1 hour program for CE. And then in .04, continuing with that, the new rule, we are essentially trying to define what makes something an interactive virtual program. And so based on other laws, this seemed to encompass what would be interactive, but I definitely wanted to go over this with you all and just get any questions or suggestions you all might have about this. Okay, so moving on from the CE, I did forget to add the program sponsors. One of the things we added, and this is the section ending in .05, is that they make a statement along with their other materials, whether or not it's an interactive virtual program or not, and the basis for that, so that we can know whether or not it qualifies from their perspective. That would help us in monitoring things. So moving to section 0660-11-.02, preparation rooms. Again, we have rules dealing with humans versus non-humans. Based on what you all said earlier, the labeling needs to also be applicable to this section.
It might be better there.
Because the other section dealt with crematories exclusively, so I think
Okay.
we have to put it in both just to make sure it's consistent. Any questions or concerns about the preparation room requirements? Are you all comfortable with including the tools and the implements? Because we didn't address that with the crematories, I don't believe.
I'm fine with that.
Okay, so moving to the next section, professional conduct, that's 0660-11-.05. C deals with the piece of legislation that passed that deals with this issue, and essentially this rule is intended to provide further clarification that the funeral home that is not selected, let's say they have the body and they're not selected to provide the services, maybe the family selected another establishment to provide the services, they do need to release the body, but the second funeral establishment and that individual would still be responsible for the cost. And so that's the purpose of that, to provide clarification and guidance to help effectuate the statute that was recently passed. Any thoughts on that provision? That's 1C.
And so, just to make sure I understand, so the funeral home that was originally selected would pay basically any costs associated with that funeral home that received the body, is that right? I mean, so I'm assuming we're talking about one funeral home was selected initially to receive the body, but another one picked the body up, is that?
Funeral home A picked the body up, and they decided to use funeral home B. Funeral home B's got to pay funeral home A for the services.
I got it.
Basically, we're just keeping up with legislation, so that's all that is.
Keeping up with legislation and then making it clear that the board can take disciplinary action if necessary, and that really this isn't about necessarily keeping the body until the costs are paid. It's really just to ensure that liability is established. That's really what the legislation is designed to do. And so this further clarifies that and provides some guidance.
Before you move on, let me go back to this other one, 0660-11.02. That question you were asking about the tool or implement be used to prepare. You said it's not in the crematories over here. Are we moving that into that as well? Or did y'all say you thought that was okay? I think it should be in both.
Okay, and that's really an industry question, in drafting these, not really knowing. And so are you saying that the tools and implements language needs to be in the crematory section as well?
Right, I do. I think so. So is that what y'all were saying earlier, Charles?
I
would
thought
keep it
so.
consistent.
But I didn't understand that. Is that what y'all were in agreement for it, or leave it alone?
I'm in agreement that it should be in both.
I am too. So is that what you understood?
Well, initially, when I asked, I was addressing the labeling requirement that Mr. McKinney brought up. But I think, that's really an industry issue. And so I think if it needs to be there, we can add it. But tools and implements right now is only in preparation rooms. And I guess that's just because of lack of knowledge of what really happens at the
I think it should be in the
crematory.
crematory section as well, because we were talking about the pets crematory, and I don't know much about pet crematories, but if they're in the same building, I could see where those instruments could be easily used for both or whatever, and that doesn't sound good to me.
Okay. So I can go back and have that language mirror the language in the preparation rooms, just to make sure that everything is covered.
Thank you.
Thank you for bringing that up. There's also in that same section .05 professional conduct, kind of language clarifying that we need a response anytime that a complaint's open, and that just gives the board more authority to take action should no response be received. Part of professional conduct is responding to communications from the board, and so it's just strengthening that language a little bit to cover more. H deals with the sexual misconduct issue and says that any person whom the board finds has engaged in such with a corpse shall be revoked by the board, and so that limits the discretion as far as the punishment for that specific thing. And so definitely wanted to know if y'all had any questions or concerns about that. Okay, let's go over J through N. J just adds language that there shall be no conduct that would mislead or deceive the public as to the physical location of an establishment. And I guess, Mr. Gribble, you can speak to this, but that has been an issue, and so it's something that we're attempting to address by rule, and you can speak more to that.
The thing that came to our attention was there was an establishment that was advertising that obviously they only had one location within the state, but then they were securing a phone number with an area code in all different locales of the state. So they had a 901 phone number, a 615, a 423, and whatever, 865, I guess. They had all these phone numbers. So if they were advertising in the Knoxville area, they would advertise either the 865 or 423. Maybe they didn't have both of them, but they had one of them. So it made the public think, you know, this establishment's here close by. If they were advertising in the Memphis area, then they would advertise their 901 number. And it was misleading to the public, because then they would call this establishment and they would think they were going to drive 10 or 15 miles to go in and make the arrangements, and they might be 200 miles from where they were, or 150. So that was the reason for that they would, you know, because the establishment didn't put their physical location on the ad, they only advertised the name, ABC Funeral Home, and put the phone number, and it made it appear like to the public that they were in close proximity to where they were advertising.
If they weren't trying to deceive the public, they would have had just a simple 1-800 number or 888 number that would have covered, you know, everywhere.
That's a thought process behind that rule. Do y'all have any questions or concerns about that? Moving to K, J, and M, these all deal with, well, K, L, and M, these all deal with disclosures related to human, non-human remains. What are your thoughts on those? Essentially, K says that funeral establishments that prepare or offer to prepare non-human remains essentially shall provide a written disclosure to the responsible party indicating such. And then the same thing for commemorative services, essentially, so that the public is aware, you know, that these other services are offered. The same thing is essentially what M is designed to do. If two services are taking place, an individual is aware that there may be a non-human commemorative service, and, you know, they have the option to raise any concerns that they may have about that.
You have to disclose this to every family, every at-need family you're dealing with, that your funeral home offers these services to non-human?
It's really an idea to have it, assuming, you know, that most of the establishments already have, you know, legal documentation, to have that information documented in what you're giving to the family. So not a verbal disclosure, but something that would be added to existing disclosures and contracts with families. And you all may, you know, not necessarily agree with that, which is why we're kind of having this session.
I don't.
I don't agree. I think it's overkill myself. For instance, we're a small funeral home, and if someone wants us to help them with a pet disposition, we will. Those are rare, but I don't think it'd be necessary for me to announce to every family that I'm dealing with at an arrangement. Oh, by the way, we offer non-human ceremonies and services.
And 9 times out of 10, the pet doesn't enter the funeral home.
Exactly.
I mean, we go to the vet, pick it up, put it in a little container, take it to the cemetery or whatever.
Yeah. I'm not in favor of that. I think it complicates everything.
So is that the
I'm fine with
consensus that maybe we should strike K and L to get all together?
Let me ask you this, what about if there's fees associated? Is there a difference?
We actually have a rule saying, we'll go ahead and move to the next page. We actually have a rule saying that the price list and any other documents required by the funeral rule or the applicable statutes, rules, and regulations, they can't include these services. So they need to be kept totally separate because the board doesn't regulate the non-human services at all. And so the documentation needs to be kept separately.
But if you're having, in this example here, where you're helping a family with a pet,
I'm sorry.
if you're doing that for purposes of revenue, wouldn't you put that here in that particular category?
I'm sorry, I don't understand
Okay.
your question.
I can see why they would be opposed to that, and I understand that. But what if the establishment was offering those type of services and they needed to notify the consumer, like what you were proposing? They are,
I see what you're saying, Jeff. You're saying they could be in business, this could be their primary business.
or part of it.
Yeah.
I think that would go to advertising, and depending upon all of that, it would go back to what we were discussing earlier, which is whether or not the establishment is primarily dedicated to the care, et cetera, of human bodies and those factors that we discussed earlier. But I think as far as making the public aware that the services are offered, that would really deal with advertising of the business, and, this certainly doesn't help with that piece. That's not what it's designed to do. And so I think if those provisions were stricken, it wouldn't affect their ability to advertise in any way, except to the extent that you get into the factors of whether or not the establishment itself is devoted to the care and preparation of human bodies. And again, we talked about that being an overall picture, not necessarily one factor that's dispositive of what's going on at an establishment.
What was the purpose then of you wanting to enter this KL and M in here? Have an example of what's happened?
Well, we discussed that internally, and because this is new legislation, I don't think there are any examples that we're aware of, but essentially just to make sure that there aren't complaints that maybe, let's say a certain percentage of an establishment's revenue, a significant percentage is non-human remains, to make sure there aren't complaints that maybe a family wasn't aware that, certain things were taking place. But I don't think we really have examples yet because this is a new law, and it's not clear that any establishment, any new business has redesigned their business practices to kind of capitalize off of this.
Probably will.
And so I think the question is, do we need these rules now, or would we want to, do we need K and L now, or would you all prefer to wait and see if it becomes an issue? Kind of, it may never be an issue. Like Mr. Helms said, it may be something that, in his situation would happen once every blue moon, and there'd be no need whatsoever to disclose this, to all the patrons of the establishment.
I think the establishments that are, for lack of a better term, that are big in the pet services, I mean, they really they advertise it. if the consumer is, halfway aware, I mean, they're going to know it. Because these businesses, they've got brochures scattered around their funeral home. It's on their websites, and I know we like to be proactive and not reactive, but in these, it might be best to let it rock along and see if some problems arise before we reach out there too far. There again, I mean, I don't want to be a burden to a business, but we want to do what's reasonable.
And I think you all have some discretion if we were to strike K, L, and M and just keep N. N is essentially a catch-all that says directors, embalmers, and establishments shall conduct themselves in a way that does not offend the reasonable sensibilities of the public and reflects respect for dead human bodies. I think that gives you all discretion so that if something out of the ordinary arose, you do have that provision to say this is not reasonable, I'm sorry, and you all have that ability to take action if necessary. And so I think we could do away with all three of those, K, L, and M, and you all would still have the ability to act if some extraordinary circumstance arose.
I would be in
Is that the
favor.
I would agree.
consensus?
Yeah, I would be in favor
Yeah.
of that.
Do we have, and forgive me if I missed it, do we have in place, if one of our field reps goes into a facility, we'll say crematory that has the two retorts, if they have the human and the pet, and let's say they find around the pet area is not clean, maybe there's remains scattered here and there, do we have in place a rule that will allow our field reps to cite them for the place being nasty because it's next to what is taking care of humans also?
Well, as I said previously, we don't regulate the non-human piece, but we do regulate the condition of the overall establishment. And if the establishment itself has issues with sanitation, I would think that those would be noted by the inspector and action could be taken. But we still wouldn't regulate that specific piece of
In other
the
words, because
services
it's right
offered.
next to the human crematory retort, then they could say, you got to clean up your act and do a better job of keeping your area clean.
Yes, because, the situation you just described, kind of suggests that maybe there's a mess generally in maybe the preparation room, for example. And, if we have a situation where there's a designated pet or non-human preparation room, I think we might have a problem with citing anything in that particular room, because it may suggest we are attempting to regulate non-human services and non-human preparation. But I think if it's something that pertains to the establishment generally, and you can tie it back to the care preparation of human bodies, I think at that point action could be taken. But some of these things are going to have to be sorted out as complaints arise. But I think if there are non-human preparation rooms that are separated into themselves, just thinking through it with you all, I don't think our inspectors would be able to go into those rooms and cite things specific to those.
Well, I guess what I was getting at is if XYZ Funeral Home is advertising XYZ Funeral Home and pet care services, and the field reps find that the pet care area or what have you is in a disarray or not clean, sanitary, then to me, they're advertising the pet care along with their funeral home, and it goes to the whole, it reflects on their whole business instead of just that one area, to me.
Also, the part of the customer filing a complaint concerning the non-human services. Who do they file with, or?
Well, they definitely wouldn't be able to file those particular complaints with us because we don't regulate those things. And so I'm not sure if maybe it would fall under another department, maybe. But I'm certain that if someone, retained an establishment to provide non-human services, and they had complaints about those, we would not be able to take action.
I'll wait because they send it to Department of Consumer Affairs.
Possibly, and I mean, I would say there's kind of a tenuous link. Let's say a funeral director conducted him or herself very unprofessionally, something like that, I mean, there was a complaint here today, where someone did something that was not at the funeral home, and the board, you all decided that it was unbecoming. So those types of things would still be applicable. But as far as the actual regulation of the services being provided for the non-humans, that's not something that the board would be able to take jurisdiction over. Of course, if a funeral director behaved inappropriately, they'd still be a funeral director, and the board would still, depending upon what they did, be able to look at that, but you wouldn't be able to take jurisdiction of these types of services.
I guess.
Does that make sense?
Let me give you an example. Say, you've got XYZ Funeral Home and Pet Care Services, and you've got a funeral director taking care of, or supposedly cremating pets. All right, say he just takes the pets and takes them out on the farm and throws them in a pile, and it's giving families back sand or sawdust or whatever. And if that's found out and it hits the news media, it's, XYZ Funeral Home and Pet Care has found to have stored 100 pet bodies on the farm, and then giving back Quikrete. Doesn't that reflect on the whole business instead of just that part? I mean, I can see something like that happening. It's happened to humans. I mean,
I think it potentially does, and I think that would be something that would require some legal analysis to determine to what extent the board could take action for that type of unprofessional conduct, considering the scope of the regulatory scheme. But I wouldn't be prepared to give a definitive answer to the board's jurisdiction, non-jurisdiction under those circumstances today.
We can't cover for every possibility. I mean, we can't. But yeah, that can't happen. And if it does, it's going to reflect on them through just publicity and news. But we can't cover all these. Being amazed on what keeps coming up.
So I think the consensus was to delete K, L, and M, and to rely on N for the time being. Should the need arise at some point, this issue could be revisited of disclosures. Okay. So thank you. Moving to the next section, records. That's section 0660-11-.07. We'll start with number 3. And this is in response to, and Mr. Gribble can speak to this, more concerns about certain information being released. This rule would limit the information being released by the board, the information released pertaining to individuals released by the board. And this, this information is required by law to be released pursuant to the Open Records Act, but to a certain extent, there's some authority to curtail that. It's not something that is taken lightly, because the Open Records Act is a law that's in place for very specific reasons, but that's what that particular rule is designed to do, to limit the information released related to individuals, released to the public. Any questions about that one or concerns? And maybe Mr. Gribble wants to talk about that one a little bit.
I think probably if the rules go through and we one day get up to Government Ops Committee, they're probably going to have some questions about this. So let me kindly tell you my thinking and reasoning, and obviously if the board thinks different, we need to do what the board thinks. Yesterday, I approved a student registration for a young female person who had entered mortuary school. Her address was 1500 West Main Street, apartment D2, AB, or whatever city in Tennessee. And we've been contacted by licensees before, because anybody can do an open records request and get all of our information. The board needs good records. If I need to get in touch with Mr. Duffer, I need to know Mr. Duffer's address, I need to know his cell phone number, and I need to know his email address. That helps us. But the converse of that is, when someone does an open records request, then they get Mr. Duffer's address, they get Mr. Duffer's cell phone number, and they get Mr. Duffer's email address. So now we have licensees, instead of giving us a good cell phone number to contact them, they're giving us their place of employment as their number. Okay? I call Mr. Duffer's number he has on file, it's his place of employment, and Mr. Duffer doesn't work there anymore. Okay? The email address on file is where Mr. Duffer works. So it really inhibits our ability to communicate with licensees if we don't have good information. But at the same time, we have licensees, especially female people who are concerned about sexual predators. They get very upset, and they've expressed to us their frustration about, you have just given someone my address and my specific apartment number. And that's the reason for it. It's identity theft has a little bit to do with it, but the main thing is the board having good information, being able to communicate with licensee or applicants, and the risk of, especially females, the harm that could be done by sexual predators. But as Ms. Hooper says, it's probably controversial when, as she explained to me, that to some authority, the board has the right to put this rule in place, but it's going to be met with a lot of scrutiny. So those are my reasons. If you don't think they're good reasons, now's the time to take it out, because we're probably going to have to justify it more than once if it stays in.
I personally would like to have that rule in place, and hope that it pass muster and go from there. And if somebody needs some open records, it can just be redacted.
Well, if this rule were in place, that information would be redacted. Right now, there's no authorization to redact it. So if someone requests records, then that information has to be released.
Hope it can go through.
I agree.
What business is it of anybody to know where someone's home address or home phone number is?
And to be clear, this would not affect establishments. This is only individuals. So establishments that are commercial businesses, anyone doing an open records request would still get the information that they get now. This would only affect individuals.
I could see if somebody requested, hey, I want to see a copy of so-and-so's application for their funeral director's license. That's going to have all this information. So that's how they would get it if we don't have this in place. It'd give us the reason to redact it, keep it personal, keep it private.
We just wanted you all's thoughts on that, and, going forward, we're not sure how that particular rule is going to proceed, but we definitely wanted the board's thoughts on that particular rule. Number 4 and 5, based on our conversation earlier, I'm not sure if you all think that that is necessary. I will say that 4 and 5 really go to the factors more so than the disclosures did. And so 4 and 5 would essentially, if any questions arose, provide a clear record so that the board would be able to evaluate whether or not an establishment is devoted to the care and preparation of human bodies. And so if you all think these need to be taken out, that's fine, but that was the thought process, being able to have those records.
I think since we deleted others, that this would be deleted as well, my personal thought.
If we can't, and we don't, police and the non-human services anyway, I don't think there'd be any reason for us to keep the records.
The only rationale for the records is that you all have to ensure that, you know, the establishments are dedicated to the preparation of human bodies. And so that would be the only purpose for these records. If a question arose, the board would have information available to clearly the activities taking place at an establishment. Now, if you all don't think that information is necessary, we can definitely strike it. That information could be obtained other ways, you know, potentially an investigation, let's say a complaint arose, could take place. Maybe the establishment owner could verbally say how many of these types of services, et cetera, took place. There are a number of ways to get the information, if necessary. Of course, this would be, you know, what would be called best evidence, but that's not required.
I guess my question was going to be similar. I didn't know if the establishment could say, well, really, we don't have to provide you that because you don't regulate the non-human. Well, I didn't know if they might have an argument in saying that we don't have to provide you our non-human records because that's not something that board regulates. Does that make sense?
I think that's an argument that could be made, but you do regulate the establishment itself, and
Yeah.
you do have to make sure that it's dedicated to the care
Yeah.
and preparation of human bodies per statute. And so I think that would be the appropriate response to that argument. Now, I'm not sure to what extent it would be challenged, but that is the counter argument.
I got you.
Personally, I'm just for less reporting and less restrictions.
I'm fine with striking it.
Is the consensus that 4 and 5 should be taken out? I know we're not going to do a formal vote, but, I mean, as long as nobody
I'm fine with that.
consents, we can.
I'm fine
okay,
with that.
Good. Now, number 6, that's really for enforcement purposes so that the board at least knows what services are taking place. You all are putting rules in place about refrigerators, retorts, et cetera. And so this would essentially say that if your entity is offering these types of services, you know, they're going to have, certain things are going to have to be separate, certain things are going to have to be labeled. And so this provision would require a notification to the board and a reinspection to make sure that things are in place in accordance with the rules. And so what are your thoughts on this?
Good.
Going back to number 7, we talked about the price list. Essentially, that just needs to be kept separate. The price list and any other documents required by this board, pursuant to statute or rule, need to be kept separate. And pursuant to the funeral rule, all of that needs to be kept separate for numerous reasons. And so 7 just deals with that. And same thing with the trust accounts, that all this is kept separate and there's no kind of intermingling of the two. Any thoughts on 7 and 8? Okay, so moving to the final section, removal service, and that's section 0660-12-.01, transporting the bodies together. Any thoughts on that particular rule?
I think it's fine.
Is there anything that you all would like to revisit that maybe we didn't discuss enough or you all didn't get clarification on? I'd like to answer all your questions or have any discussions that you all would like to have about these.
What's the next step?
Well, the next step, I would need to revise these and have these reviewed internally again. And then once they're ready, we would provide you all with this information. There are certain questions that the governor's office has that we would have to answer. There's also, let me see. We have to do a regulatory flex analysis, et cetera, and basically draft all of that information and present you all with the revised rules and that information to review and adopt. As we indicated earlier, additional changes could be made, but the goal today was to essentially fine-tune these, so hopefully any additional changes are minor. Of course, if major changes need to occur, then, that's something that can definitely take place. It could lead to potential delays, but that's something that could definitely take place. But the next step, ideally, would be for these to be revised and for you all to be presented with these answers to the governor's questions, the regulatory flex analysis, and for you all to review, approve, and adopt these. And then we would set a goal date for the rulemaking hearing, which would be the formal hearing on the rules. But I'm going to go back now that I have your feedback and make the changes that we discussed and go from there. We're also planning to meet, Mr. Gribble can speak to this, we're planning to meet with a couple of interested groups to get their feedback because, even though they're not on the board, they definitely have an interest and say in kind of what happens in the industry. So we're also planning to get their feedback. And of course, if there are any major concerns that they have, we'll definitely have to bring those back to the board and discuss those with you all.
Possible when we revisit this that you can pick another color, say green, and that way we can only have to deal with the things that we've just made changes to, instead of going through all the changes again.
I can try to come up with that. I'll probably have to create a third version because that's definitely
you know where I'm coming. You know where I'm
not
coming
standard, but I understand why you want it.
Yeah.
So I'd have to come up with a third version just to help you all
Or
try.
an underline or something.
What was
Right, yeah,
changed,
yeah.
but I definitely understand why you want that, and
Just a
I'll
suggestion.
definitely try to accommodate.
Okay.
Just so you know, at the appropriate time, we were planning on meeting with a couple, 3 individuals from each of the 2 associations to get their ideas, thoughts, or feedback before we get too far down the road. That was our thinking.
I think it's a great idea. How often do we do the rulemaking?
Once every 5 years, 3 years, something like that. It's not too often. But it is interesting to note that one time it was used against us because we'd not done it often enough in a formal hearing. There was the Respondents' Council was using it against us, so it does need to be visited from time to time. that was not a funeral case, that was a pre-need case, as I recall, but anyway, lack of revised rulemaking was used as part of their defense.
Well, I will definitely work on the revisions, and hopefully at the next meeting, maybe we will be ready to kind of move forward with these. We'll just have to see, have additional discussions depending upon, our conversations with the association. So we will definitely keep you all informed.
Thank you for all your effort and time, you as well, Mr. Gribble.
On that note, also, if it's okay, we may need to have a conference with the president, and maybe might need to have the next board meeting at 9 o'clock instead of 10 o'clock, because it may be that there's a formal hearing at the next board meeting, that one in October. These may not be ready for October, but if they are, I wanted to mention that, at least throw it out there, if need be.
Is that okay with everybody if we have an earlier meeting time start?
Unless we send you some kind of written communication, it'll still be at 10 o'clock, but if we need to, we'll consult with Mr. Helms and then send you written communication and email if we change the time.
Other questions for Ms. Hooper? Thank you.
Thank you.
Okay.
I apologize to the board, but I have a commitment that I need to make, so I've got to.
Next item on the agenda will be the approval of license applications of the board members.
Mr. President, there's one this month, an individual. It's an individual application of Beverly Louise Lewis of Memphis, Tennessee, who's applied by reciprocity for a funeral director and embalmer's license. I would ask that you look at 625317, making a determination as whether the applicant meets the requirements for licensure. The applicant has been notified that these applications were going to be presented today. The first application came to us June the 28th of 2017. I guess what I want to ask you early on is to consider these applications, acting on these applications in her absence. And we have a 90-day, even though it's, we talked about putting in the rule, by policy now we have a 90-day expiration. So if we don't act on these applications at this board meeting, then for the next board meeting they will simply expire. To put this in perspective, we got the first application on June the 28th, and it was for an application for a funeral director and by reciprocity for a funeral director and embalmer's license. Question there that's highlighted is, have you ever had a license or applied for a license or its equivalent to practice any profession or occupation that was denied, suspended, or revoked, or otherwise acted against? It was answered no by the applicant. That was the funeral director application. It was answered likewise on the embalmer application. June the 27th, through a separate communication, we received certification from Missouri State Board of Funeral Directors and Embalmers that there was an active license there for funeral director and for embalmer, and those licenses were active through May 31, 2018. However, a licensing technician noticed that the licensing method there was by reciprocity. Reciprocity, which indicates to us that they were originally licensed in another state. So there was communication back to the applicant that we've got your Missouri certification, but we need your certification from the state of where you were originally licensed. That came on July the 26th, 2017, came from the Illinois Department of Financial and Professional Regulation Division of Professional Services, and showed a license that was issued there, an expiration date of May 31, 2019 for both the funeral director and embalmer, But if you notice there under disciplinary history, it's been disciplined, and there is a consent order that's attached that details the disciplining of the Illinois license. Okay. In addition to verbal communication with the applicant, on August the 15th, our licensing technician sent an email to the applicant saying, "We need your help in order to continue processing your applications. Please have the following documentation sent to our office by mail as soon as possible. National board exam scores for the art, national board exam scores for the science section, and send us a detailed narrative about the discipline taken by the Illinois board." We haven't received that. That's been almost a month. And this is written communication to an email address that was being used by the applicant, and that's in addition to the verbal communications. And then this past Friday morning, Ms. Mosby sent another email to the applicant stating to her that we'd be presenting these applications to the board today at 10 o'clock, and the location of the board meeting, and asking the applicant to advise if she'd be attending the meeting, and if she's unable to attend, to contact Ms. Mosby, and again reminding her of the 3 items that were outstanding. Also, this past Thursday, we received certification again from Illinois, and I'm not sure why we got this, but actually it's from the custodian of records. It's more official documentation regarding the disciplinary action than what we'd previously received. Included the other requirements that the applicant would normally have. I would ask and recommend that you deny these applications. It appears to me that there was a material misstatement made on the applications regarding the question that we talked about, the license being otherwise acted upon. It appears that, well, just let me stick with the facts. If the applicant, until questioned, only presented certification from a state that showed no disciplinary action, and answered the question, and also online submitted numerous applications, and each time, and I looked through each one of those to make sure, at any point in time, did the applicant answer yes to that question? And the answer is no. Each time the answer was no, that the applicant consistently said there'd been no otherwise acting on against a license. I personally think it's important that the license be acted upon, the application to be acted upon, instead of just letting them roll off as expiring, because then if it's a different office people, different attorney, different board, 5 or 6 years later, someone may come back with the same application, and unless the applications are acted upon, then the people sitting where we're all sitting today may not even know about this application.
Why did she say she wasn't able to be here today?
Our licensing tech had contacted her. I also called and left a message, and we never got a reply.
It's her understanding, Mr. Bridges, that probably the funeral home where she was going to work at, or where she was working at in Tennessee, has probably terminated her employment at this point. So I'm not sure if she's still living in Tennessee, or if she's moved back to some other state.
I make a motion, we reject it.
Second it.
Got a motion by Mr. Bridges, second by Mr. Duffer. Any other discussions or questions? All in favor say aye.
Aye.
Opposed? Motion carries.
And just for clarification, rejecting and denying would be the same thing, correct?
Yes.
Thank you.
Do we don't have to take 2 votes for each. Okay, gotcha. Just want to make sure that covered.
Consider that one motion. Any new business? Any other items that need to come before the board?
Adjourn. Second.
So moved.